Hi everyone, and welcome to the 3 Millions webinar on changes to the absence policy for pre-settled status holders. My name is Andrea Dumitrache. I'm CEO of the 3 Million. We are the largest organization representing EU citizens in the UK, bringing people together from across the country to campaign for a fair and just immigration system. Thank you very much for joining us this evening, and I'll just get started with some very basic housekeeping. This webinar is being recorded, and we will share that recording with all of you afterwards. For our Q&A tonight, we've already received over 50 questions in advance of the webinar. So we will answer some of these tonight, and we'll also try to take some of the questions that you'll be adding in the Q&A live. But for all of those questions that we don't manage to get to, we'll also compile a Q&A document which we'll share in the coming weeks after the webinar. You can also reach us by sending us questions afterwards by email to info@the3million.org.uk. So tonight we're joined by Monique Hawkins, who's our head of policy and advocacy at the 3 Million, and by Chris Ben, legal and policy manager at Seraphus. Monique will start by providing a brief overview of the latest changes to absences for pre-settled status holders, and then Chris will address the questions that were sent in. So over to you, Monique.
Thank you very much. So welcome everyone to another webinar where we're once again very lucky to be joined by Chris. We'll be discussing some very significant changes to the EU Settlement Scheme absence rules, which were announced a few weeks ago and which will take effect from tomorrow, Wednesday, the 16th of July. And we think it'll be easiest to explain these changes by going through lots of your questions and scenarios, and we're very grateful to all of you who sent in questions beforehand. So before we get into what the change actually is, it's just important to note a few things. Firstly, these changes only apply to people who were already granted pre-settled status. Quick note, later in the webinar, we'll touch on some questions for people who had pre-settled status, but who have since switched to a different immigration route. These changes therefore don't apply to people who were, for example, here before December 2020, who haven't yet been granted status and whose application is still being considered, or who need to make a late application. Secondly, it's important to know that these changes are an alternative additional set of absence rules to the existing ones. The existing rules are quite a bit more complex than the new ones, but there will be some scenarios where someone can qualify under the existing rules, but not under the new ones. So I think this will probably be quite rare. So first, a very quick, very simplified overview of the existing rules. To qualify, you must have 5 years of continuous residence, which started on or before the 31st of December 2020. We're leaving joining family members aside in this summary. And continuous residence then broadly means no more than 6 months absence in any 12-month period. There's some exemptions. You can have 2 extended absences, one for an important reason and another for COVID-related reasons. But depending on the combination of extended absences that you want to make use of, your continuous residence can be paused rather than broken, which means that that you then need longer than 5 years altogether to reach those 5 years of continuous residence. There's also all sorts of requirements around the evidence that you need to provide in order to make use of these extended absence allowances. So now the definition of continuous residence adds a second alternative way of meeting these requirements. You can see in the first part of the definition that someone has to have pre-settled status, or also known as limited leave to remain, if this new rule is to apply to them. The new rules say that you can satisfy a continuous qualifying period if your total absences in the last 60 months, which is 5 years, add up to less than 30 months, which is 2.5 years. This is still fairly aligned to the previous rules in that you are allowed to be away roughly half the time, but now there's much more flexibility in how these absences are spaced within a 5-year period. In principle, you could be away for a whole 2.5-year period and then be in the UK for 2.5 years and still qualify. However, this does beg the question that some people's leave may be deemed to have lapsed if they were away for longer than 2 years, but we will cover that in the Q&A with Chris later. The extra benefit of these new rules is that it's no longer required to justify these long absences. You don't need to evidence what the important reason was or to explain the ways in which the COVID pandemic caused you to stay outside the UK for longer periods. You only need to show residence for at least 30 months residence. We've received a lot of questions about how exactly you evidence this, so we will be covering that in detail later. If you previously applied to upgrade your pre-settled status to settled, but you were refused because you couldn't evidence your eligibility under the old rules, but now you can satisfy the new rules, then you can make another application. The refusal of that upgrade application should have left your pre-settled status intact. The definition also makes clear that it's the date of submitting the application that counts for the definition of the most recent 60-month period. So if you apply tomorrow, 16th of July, the 60-month period under consideration is from 17th of July 2020 to tomorrow. But if you apply on the 3rd of March 2026, then the 60-month period being looked at will be from the 4th of March 2021 to the 3rd of March 2026. So you might think that this means residence no longer has to be connected to before the 31st of December 2020, but that isn't really quite true, because the fact that it only applies to pre-settled status holders keeps the link to before the end of the transition period. And that's because you have to have been granted pre-settled status in the first place, so you would have needed to show that you were a resident before the 31st of December 2020. However, it does mean that from next year, the residence period that will be looked at by the Home Office will no longer be looking at residence in 2020. The last part of the definition talks about automated upgrades to settled status, where someone hasn't made an application themselves. The definition says that the relevant date there is the date at which the Home Office is considering the automated upgrade. However, it will take a little while longer for automated upgrades to take the new rules into account because changes to the software need to be made, and we'll touch on this later. A quick other note, this extra absence does not mean that people can apply any earlier than 5 years after they first arrive in the UK. If you arrived, for example, in December 2020, then even if you already have 30 months residence now in the last 60, you won't be eligible for settled status before December later this year. There are some limited circumstances where people can become eligible early, as explained on the Home Office website, but we won't go into these here. Similarly, joining family members can't arrive in the UK, get pre-settled status, and then apply for settled status after 2.5 years. So a very quick overview of when changes will happen. As we said, from tomorrow, Wednesday, the 16th of July, the new absence rules will apply so that pre-settled status holders can qualify for settled status if they can show at least 30 months residence in the last 60 months. However, initially, this will only be true for manual applications that you submit yourself. The automated upgrade process will still be operating on just looking if tax or benefit data shows 6 months residence out of every 12 months. Later this year, we're not exactly sure when, the automated upgrade process will be changed in a number of significant ways. The Home Office has given us some updates on their plans, and we've asked them various further questions, and they've been extremely helpful in setting out what they can at this stage. And of course, these plans could still change. But as it looks at the moment, it'll still be, when this change is made, it will still be considering just those pre-settled status that are coming up to expiry within a month or so. But at that point, the tax and benefit checks against HMRC and DWP data will be changed to take the new 30 out of 60 rule into account. And the process will also take border entry and exit data into account to see if this can help establish extra evidence of residence. The Home Office knows that this data might have gaps in it. For example, if someone travelled through Northern Ireland. However, if the data can help, then they will use it. This should hopefully really help to get a lot more, especially vulnerable people, to settled status. Rather than, as happens now, people first getting their pre-settled status extended and then later having it upgraded, the process will then either extend or grant them settled status. And finally, the Home Office has indicated that they will start selecting some of the pre-settled status holders who have the longest absences, and they will write out to those people saying that their pre-settled status might be cancelled. And people who receive such a letter will be given an opportunity to provide evidence of residence. If their status is then cancelled, they will have a right of appeal. Finally, I just want to quickly show you a calculator that we've built. This will be available to download from our website from tomorrow, and we'll send it to you after the webinar. You will need Excel to use it. So rather than running up Excel here in this webinar, I've just saved a few screenshots to make life easier for me. I'll run through a few personalized examples from some of the questions that you've sent in. But to use the calculator, you first need to enter the date that you arrived in the UK. Otherwise, the calculator won't be able to know whether you're eligible yet, because like I said earlier, if you only arrived in November this year, in November 2020, you won't become eligible until November later this year. And then afterwards, you enter all your absences from the UK in the yellow grid below. There's some examples there, but you can just delete them and enter your own. And please also read the instructions at the top. They're very important if you're going to use the calculator. And it also points out that if you have pre-settled status as a family member, then residence in the UK is not the only factor determining if you're eligible for settled status. I'll now just quickly show you some examples of how this has been used. So Catalan asked if they were eligible after a long health-related absence. They told me they've got pre-settled status and that they'd arrived in the UK on the 1st of September 2018, which I entered into the calculator. I then entered their long absence between February 2020 and September 2021, almost 20 months of absence. Of course, I don't know about any other possible holidays or absences since, so it would be really important for Catalan to also include those. But if this is the only absence, you can see that the calculator shows that in the last 60 months, there was only 14.5 months of absence. Therefore, they qualify under the new rules. And importantly, they don't have to provide any explanation or evidence about this long absence. In another example, Anthony emailed us and told us he had pre-settled status in June 2019, but that he had a really long absence again between 2020 2022. He said he had a few 3-day visits in between, which I've made some guesses about. So Anthony, if you're going to use this, you need to make sure you've got your dates in there properly. But based on my guesses, it shows that he's currently got 26.4 months of absence, which is less than the allowable 30. So for each of these, it's really important to check the dates just before you make the application, especially if you've got more absences planned between now and the time at which you apply, because the answer can change over time. Roxana also sent me some dates, and when I entered them, it shows that you also meet the residence requirement despite an almost 2-year absence during COVID. So now I've got an example sent in with the date sent in by Antonella. She told us that although she lived in the UK from early 2017, she left in March 2020 when COVID hit. She only came back to the UK on a more permanent basis in September 24. She did tell us that she came back for a week or two every so often, so I've made some assumptions here in the calculator. Obviously, Antonella would need to put in the correct dates herself. But the calculator shows a total absence of over 47 months in the last 60, and it says that she would only get this down to 30 months by January 2027. I don't know if you see my mouse, but it says that on the top right there. And that's assuming there's no further absences from now on. And she asked us if her early years between 2017 and 2020 can be counted, and the answer is no, And that's because under these rules, it's only ever the last 60 months, the last 5 years that are looked at. Therefore, whether Antonella can get to January 2027 and apply for settled status depends on whether the Home Office contacts her in the meantime, telling her that they might want to curtail her status. We do appreciate this is not a very nice position to be in. The Home Office have said that they are prioritising people with the longest absences. And we also know that they look at cases that are coming up for expiry. So it kind of depends on what your expiry date is and whether and when and how long it was extended for to see when your status will next be examined. But until you're eligible, you are at risk. Now, I just want to show you something slightly interesting that Mario is in a very similar situation to Antonella, only coming back to the UK on a more permanent basis in September 24. However, he left quite a bit later than Antonella in July 2021 rather than March 2020. So his total absence is therefore showing as much less than Antonella. It's around 38 months compared to Antonella's 47. However, interestingly, the calculator shows that he would also only reach 30 months in February 2027, even later than Antonella, which seems very counterintuitive because you might think he's only got to be present in the UK for another 8 months to get down to 30. However, and this is really important, in his case, for every month of residence that he adds from now on, a month of residence back in 2020 is being dropped off from 5 years ago. And that is again because the 30-60 rule keeps looking only at the last 60 months. And so again, Mario is possibly at risk of being contacted by the Home Office in the time it takes him to get down to 30 months. I finally just want to say something about the scary red validation messages that you will very likely see while you're entering data. So I'm using the example of Casper here, who emailed us saying that he'd been granted pre-settled status in October 2018 and that he had 3 absences totaling 31 months. And he said 2 of them were COVID-related ones of 18 months each, and one was a 13-month one that wasn't COVID-related. I didn't know the dates of all of these, but because he said that he'd been resident in the UK since 2023, I've assumed that the non-COVID long absence, the 13-month one, must have been before the pandemic rather than afterwards. I might be wrong in that, and Casper, of course, you should use the calculator yourself and put in the right dates. But just to demonstrate the validation, I went and put that 13-month trip in as being between January 2019 and February 2020. And I don't know whether you're able to read that, but there's a red validation message against that trip and a big message at the top to saying, please fix your validation errors. In this case, the validation message is a very mild one. It just points out that that trip finished more than 5 years ago, so it's irrelevant, so it shouldn't be included. So as soon as I removed that trip, the calculator shows a result. In this case, that he has a total absence of 31.5 months, but that he would get this down to 30 months at the end of August. But as I said, I had to make assumptions, so it's essential you make you put it in yourself. So another example of validation errors is when I use the calculator in response to a question from Eleni. I hope I'm saying your name right. Eleni told me that she was in the UK from January 2020 to March 2023, but then left because she was pregnant and wanted to give birth in her country of origin. So I entered 1st of January 2020 as her date of arrival, and I entered 1st of March 2023 as the date of leaving the UK. But I don't know the date that she would return to the UK. So before I entered something, the validation message says return date is missing. If you are outside the UK, enter a planned return date because the calculator can't give any meaningful answers unless it knows when you might return. So I made a random guess and put in 1st of November 2025. So the validation message went away and the calculator now shows that she currently has 28.5 months of absence in the last 60 months. So she's currently eligible to apply for settled status even while outside the UK. It does give a big warning, however, that says, be aware, you are outside the UK now, so be careful that you don't exceed your total allowed absence before you make an application. And this is because for every month of absence that's being added going forward before she returns to the UK, a month of residence from 5 years ago, when she was still living in the UK, is being dropped from the calculation. And again, this is because the rules only look at the last 30 months. It only looks at the last 60 months for the calculation. So there's lots of other validation messages that you'll come across, but I hope they'll be self-explanatory and that they will tell you how to fix your data. If there's any problems, of course, just use the contact us form on our website to tell us and we'll try and help. I also can't guarantee that there aren't any bugs in the calculator. We did try to test it a lot, but it's very difficult to test for every single eventuality, and I only had very limited time to build it. So I do need to say that we can't be held liable for any mistakes that result from the use of it. We hope it's useful anyway. But if you think anything looks strange, please do get in touch. If we have any bugs, of course, we'll update it and we'll put a new version on the website, and we'll make sure to include the date of the last updates that you know whether you've got the latest version. So I'll stop sharing my screen and we'll now move into the Q&A part of the webinar because I have talked for quite long enough. And we'll start straight away. The first set of questions were people asking whether they can ask early. Basically, Talet, Julia and Nilesh all asked this question, saying they think they qualify now, but they haven't actually been here 5 years yet. So over to you, Chris.
Thanks, Monique. And as always, thanks to the 3 million for inviting me this evening. Hopefully with a sort of generally with a kind of positive update on these helpful new rules and simplified rules that we do hope will benefit people. Monique's obviously set out the changes, and so I'm going to refer back to those. But in terms of the sort of conditions, it is there's two sides to it. If you see it, one is you need 30 months of residence, at least 30 months within the last 5 years, but a minimum of 30 months. But also that it is a 5-year period that you're going to rely on. So you do have to have started the qualifying period 5 years ago. And so I think, as Monique said, most people who arrived before 2020, before the end of 2020, they may well have got those 5 years already in the bank. But for anyone who sort of arrived between July 2020 and the 31st of December 2020, they haven't yet completed the 5-year period. So they will need to do so, even if you had the 30 months already in the bank. It's just your application date will be determined by when you arrived. And that's key. It's about when you arrived, not when you were granted pre-settled status, because people were being granted pre-settled status all throughout 2021, 2022, 23 and 24, for example. So those are the two sides. And of course, joining family members who will have arrived in the UK after the end of 2020 will probably take longer to build up those 5 years, because their residence here didn't start until at least 2021 at the earliest. So just remember those two parts to it: 30 months of residence within the last 5 years, but having completed a 5-year period when you apply.
Thank you. Okay, and so we also had some questions wanting to get a slightly more accurate understanding of when exactly this 60-month period starts. So an anonymous questioner said, what does in the most recent 60-month period mean? If it refers to the qualifying period, there's no mention of this in the law. If it's the starting date of the last, is it the starting date of the last 60-month period, counting backwards when an application for the settled status is submitted, or when the person was last in the UK, or is it something else?
Yeah, so the way the rule is written is quite straightforward. It says on the date of application, we're talking about people with pre-settled status who are applying for settled status. So on the date you apply for settled status, have you completed a 5-year continuous residence period? And if so, within those 5 years, have you been resident for at least 30 months? So it works back from the date of application. As of tomorrow, if you apply for settled status, that's how the rule will operate. We've already Monique's referred to automation, which at the moment isn't going to sort of apply to this rule at the moment because of the various technical aspects to automation and how it operates. But once automation applies the new rule, the automation will say on the date you are considered for automation, which is roughly defined by it's about when you come to the end of your period of pre-settled status, whatever the current expiry date of your pre-settled status is, that's when you get considered for automation. So once the rule, the 30 months in the last 60 months rule applies to automation, it will look back over that 5-year period for you. But at the moment, we're talking about people applying. So you work backwards from applying. In terms of where it's mentioned in the law, it's part of the settlement scheme rules are sit in something called the immigration rules, and within those immigration rules, there's a set of EU settlement scheme rules called Appendix EU, and that sets out the conditions to be granted settled status. One of the conditions, and the condition that this new absence rule applies to, is you must have completed a 5-year continuous period in the UK to qualify for settled status. So if you don't have those 5 years, you don't meet one of the conditions to be granted settled status. So that's where it's set out.
Okay. So we had a couple of questions from Alessandro and Konstantin about whether that 60-month period has to start before the 31st of December 2020, but I think I covered that in my overview. But Adam asks an interesting question about whether it matters if you were present in the UK at the start of the 60-month period.
Yeah, it's a good question. As you say, you've already established the connection to arriving by the end of 2020 is the grant of pre-settled status that the Home Office has already made. After that, no, it doesn't matter. If you're looking back today or tomorrow, once the rules apply tomorrow, and you didn't happen to be in the UK 5 years ago, looking back, that doesn't matter as long as you have the 30 months of residency within that 5-year period. So it doesn't matter if you're outside, it's not going to count against you. It's possible that there's a little bit of confusion with British nationality rules, because there is a rule for applying to become a British citizen that says when you look back to the beginning of a 5-year period that currently applies to qualifying for British nationality, the person does have to be present in the UK at the beginning of those 5 years. Don't know why that happens to be. But it's a rule within the nationality law. So it might be that there's a bit of confusion there, but just to be clear, as far as this rule goes in the settlement scheme and qualifying for settled status, the fact that you weren't here 5 years ago, when you look back from the date you apply, is not going to count against you if you have the sufficient 30 months of residence that you need.
Thank you. Right, I'm going to ask some questions now about the timing of applications and how it maybe intersects with automation. So Amalia was probably not eligible under the existing rules due to a very long absence, longer than a year, which wasn't COVID related. However, she's confident that she'll satisfy the new rules, but she asks, with the new rules, should I apply now for settled status or wait until the Home Office makes it automatically, grants it automatically?
Yeah, again, very good question. We've sort of referred to it a few times. The way the automation process works is that it's based on the date of the expiry of the pre-settled status. So if your pre-settled status is going to expire next month or perhaps the month after, you are sort of already upon the cusp of being considered for automatic grant of settled status. But if your pre-settled status doesn't expire for 6 months, or perhaps those who've received the 5-year extension, it's not going to expire for another 5 years, you're not going to be considered for an automatic grant of settled status anytime soon. And therefore, if you meet the rules today or as of tomorrow, and you know that you're not going to get a considered for automatic upgrade for quite some time yet, then it obviously makes sense to make an application because you qualify. And also, as Monique was highlighting, showing the calculator, just because someone qualifies today doesn't actually mean they'll qualify the following day or in a few months' time, because this 5-year period that's being looked at is moving. And so if you suddenly have a lot of absences coming up, but you qualify for settled status as of tomorrow, you would want to get the application in so that those absences that are coming up don't get calculated in that 5 years, because it's taken from the date you apply. So that's the kind of what we really want to emphasize to people is automation, because also automation isn't going to apply this new, more flexible approach at the moment. There's a lot of, I guess there's quite a lot of downsides about waiting for automation. And even when the automation approach does include the new rule, that doesn't mean that your records will necessarily give the Home Office the information they need to upgrade you automatically. So I don't want to sort of talk down automation, because for some people it's very helpful, but because of these various things that need to fall into place for people to get automatically moved to settled status, the advice coming from people like myself is always going to be, if you meet the rules now or tomorrow or the next day from tomorrow, then definitely think about getting that application in, because that's the way to secure your future and not have to worry about whether automation will work for you. And particularly, like I say, for people who aren't coming up for automation because their expiry of pre-settled status is some time away, it makes sense to do the application and get it in the bank, get yourself the settled status if you qualify.
Thank you. And then I've got a question about the interaction with an existing application that's already in the system. So Francesca writes about her brother. There's an application in the system at the minute, but they've been waiting for several months already. So she's asking, first of all, until he's granted settled status, does he need to keep to a maximum of 180 days absence in any 12-month period? Secondly, he also confusingly got an extension of his pre-settled status while he was waiting for his upgrade application to be considered. So should he contact the Home Office and ask why they did that? And then thirdly, in light of the new changes, which he also fulfills the new criteria, should he ask and apply again and ask whether he should resubmit his application?
Yeah, this is a really good sort of example of how things can get very confusing with you think you're applying for settled status, and then suddenly you've got an extension of pre-settled status, and now there's these new rules. So it can get a little bit complicated quite quickly, even though you've done something relatively straightforward, which is just apply for settled status. So in terms of the sort of the 180 days. Now, obviously, that's the interpretation of 6 months, which we'll come back to, I think, because we're going to talk a little bit about that. But when you're applying for settled status under the existing rules, which is that 6 months in any 12-month period, plus the sort of some limited COVID or other exceptions, you're still looking backwards from your application date, because you have to have met the rules at the application date. So if you have been resident in the last 5 years for at least 6 months in every 12 months, then you meet the existing rules. And if you've made an application which contains the evidence that the Home Office needs to see that, then they're going to look backwards over that period, and hopefully they'll grant you the settled status based on those existing rules. So what you do going forwards doesn't matter, because you can't affect the historical 5-year period that you're asking the Home Office to look at. So that's okay to have, like, to look to not comply with the 6-month rule moving forwards, but obviously, again, until you got that security of the settled status application, I would say to you, just don't plan any major absences, just in case we don't get the outcome you're expecting. The reason the pre-settled status got extended during this application process is simply because the court case that we've talked about in previous webinars that meant the Home Office wasn't able to let pre-settled status expire, that still applies. And so when someone is applying to move from pre-settled to settled status, if they happen to be coming up to the expiry of the pre-settled status whilst this process is ongoing, then if their pre-settled status wasn't extended, that would be a breach of the court decision. And so what the Home Office does is it says, well, irrespective of the fact we're thinking about whether to grant you settled status, we have to extend your pre-settled status automatically for the 5 years, just to be sure that whatever happens with that application doesn't affect your ongoing rights. So essentially, if you've got the automatic extension, if the settled status decision is positive, I hope it is, of course, then that will just replace the extension, and then you never have to worry about the extension. But that's why it happened. It's just to avoid people losing pre-settled status whilst the Home Office is looking at the settled status application. And in terms of the new rules that are going to be applied from tomorrow, yeah, I mean, there's different ways that you could think about approaching. Like if you could reapply and ask the Home Office to consider the new rules and don't worry about my old application. That is possible to do. Probably, I think unless you're concerned about the existing application, then I don't know if that's necessarily the best thing to do. Hopefully the existing application will be successful. If for some reason there is a problem with maybe some of the evidence in the existing application, there is still the option to make a second application under the new rules if it didn't go in your favor. So there's potentially some different ways to approach it, but I think unless you're very concerned about the existing application being successful, then we would probably say it's a lot of effort to go and reapply again that might not necessarily be needed. And if the existing application isn't successful, you've got that new option of using the new absence rules in an application down the line. So I think that's probably how we would see it. But if you're concerned, then obviously sit down, talk to a lawyer on a one-to-one basis so that you can explain why the existing application might not be favourable.
And you'd think it was fair to say that some applications, even if they look straightforward, can be taking a few months, right? I mean, that's not unheard of.
Yeah, no, absolutely. I mean, the way the settlement scheme application works, and this is not going to be any different under the new rules. The new rules will help and make it simplify, and hopefully from the Home Office perspective, it makes it simpler for their caseworkers to work with the new rules, because obviously they were having to grapple with the existing rules as well. So for everyone, in theory, this new approach is going to be beneficial. But the nature of the way that an application works is that the first thing that's checked is the national insurance record, but that doesn't always and quite often doesn't have a complete record that can be used to grant settled status. So a decision maker at the Home Office then has to look at the evidence that's submitted, and potentially they have to write out for additional evidence if the evidence that's been submitted isn't enough to make the grant of settled status. So there's kind of lots of stages to this process. So it's very much like a few months is not something that is uncommon. There are decisions that are made very quickly, but usually those are the ones with the full national insurance record. And so everything else, because it does have a manual process to it with Home Office caseworkers, then we do see those slightly longer processing times. But no, it's not something that people don't need to sort of panic about a few months or anything like that.
Thank you. Okay, and then Alessandra asks about how making an application works with the automated upgrade process, because she says, I received a notification 2 weeks ago about being considered to automatically switch to settled status. So would my case be assessed under the latest changes coming in tomorrow if I'm still to receive an update? Or if not, can I appeal the decision and reapply for settled status under the new changes?
Yeah, so I think, as Monique pointed out in the presentation, we won't see the new absence rule applied in automation cases from tomorrow because of the various technicalities involved in that. So if Alessandra doesn't get automated on the existing rules, which is looking for national insurance records showing 6 months of residence per 12 months, if that doesn't happen, then the Home Office will just say we cannot move you automatically to settled status. It's not a decision, it's not like a refusal of anything. So there's no appeal against the decision. If the Home Office comes back to you and says, we've considered you for automation, but we cannot give you settled status, you don't have to appeal that decision, because your pre-settled status is automatically extended. And what it's basically saying to you is, we don't have sufficient national insurance records, but if you want to apply with your documents showing your residency, then we'll look at it. So if the ultimate outcome of this automation process for Alessandra is, we can't automatically move you to settled status, then what we would then say is, if you meet these new rules, the 30 months in 60 months rule, then as of tomorrow, you can make the application and move, hopefully move, or like manually through a manual application process to get yourself settled status.
Great. I'm going to move now to the topic that we've got the most number of questions on, which is how you evidence these absences. And we've got a huge number of very similar questions. So I'll name you, but I'm not going to read out all your questions. But we had Olivia, Konstantin, Julia, Anna, Chiara, Katja, Leah, all basically saying, what is a month? Like the residents, the evidence asks you to provide a piece of evidence for a month. And people are saying, well, what is a month? What if you were here for 50% of the month? What if you were here for 1 week? I mean, how do the two tie up? I wonder if you could just say something about that.
Yeah, I think one thing to say about this is, as far as I'm aware, so the withdrawal agreement, which is what the settlement scheme is based on, the withdrawal agreement itself is based on the Free Movement Directive, and the Free Movement Directive says, if you are someone who's used free movement, then you do not, you're continuously resident in the host country you've moved to, as long as you are not absent for more than 6 months in a 12-month period. So that's the kind of language of the Free Movement Directive, which is where this idea of months comes from. It's why it's not written in the settlement scheme as like 182 days or something like that. It's written as months in the settlement scheme because that's the language of the Free Movement Directive. The other thing to say is, there's not a lot of cases about what is the concept, what is a month? What does it actually mean? Because it's not very often that people, I would imagine, under the Free Movement Directive need to make this kind of argument about splitting hairs about what a month may or may not be. So I don't think that there's any like definitive answer. But what I can say is that it does not mean, like, if you were saying I was resident in the month of January, that means that you were here for every day of January. It's the common use of that expression. I was here in January, like for the whole month. That doesn't mean you were present for every day. So in the context of like counting months for this 30-month qualifying period, you are counting your time as present in the UK. Obviously things are very, like, they don't often fall like in such a neat way to say, well, in my my first year, I was here on the 1st of January and I was here until the 1st of July, so I know that I was here for 6 months and 1 day, and then I went away until the end of December, and then I came back on the 1st of January. People don't really sort of live like that, so it's not going to be very often that you'll be able to kind of definitively say, well, this month I was here and that month I wasn't here, which is where your absence calculator is so helpful. Because when you put in the days or the travel dates that people have had over the course of the 5 years, it gives you an outcome. It gives you the number of months that you've been here. You've explained the methodology of what's defined as a month within that, but it tells you how many months. And so you kind of, and this really only matters for people on the edge, I would say, of the actual allowance. If your life is, well, I was here except for a few weeks holiday here and there, then that you've got that time. But it's only if you're on the edge, then you do want to kind of have that calculation made. But it is a combination of the number of days, because very rarely will someone have just one period of 6 months every 12 months to look at. So it will be a combination of how many days were you absent, in this case over the 5 years, and what does that equate to in terms of the number of months. That's roughly how the calculation is being applied, as I understand it from the Home Office. And so and that is a slightly different question to what evidence do you need, because the reason is because it would be very, very bureaucratically excessive to say every day you were present in the UK, we need some piece of evidence to prove it. Like, we need something showing you're saying you were here on these days. We need you to show us you were here on those days. That would just be unworkable, unnecessary, and completely over the top. So that is why when you look at the residence evidence guide that's on gov.uk, that's why it says, well, if you give us a utility bill for, for a month, if it's a month long, or if it's, if it's something like a council tax bill, that's actually a longer period. But it says if it's a utility bill, then that will be relevant for the month that's dated on the bill, and that's what we're going to assume. So, it's more, that is about just kind of bureaucratic ease. It's not saying that if you were present for one day during that month, give us that bill and we'll say you were here for 30 days. And that's why it's a combination of you giving evidence and also making declarations in your application to say, yeah, this is my residence situation is within the rules. You do say that when you make the application. So you can see how it is a little bit confusing. But that's why, if people's question is why does a one document equate to 1 month, it's because it would be unworkable to do something different than that. And obviously there's documents that are considered to be evidence for longer periods of time, like the council tax bill. That's why it's about making life, one of the commitments the Home Office made with the withdrawal agreement was to not make life excessively difficult for people to prove that they were resident. And that's why some documents have longer periods of time that they're covered. But you do still need to be present to be considered to be resident here, and you are making a declaration that what your evidence is, what you're giving with your evidence, is a genuine reflection of your residence situation.
Thank you. It's a very difficult question to answer, but I'm really grateful to that and hope that it gives some clarity to people. Right, some other people are asking questions how, so from tomorrow, when they submit a manual application to upgrade, how the sort of automated checks within that manual application will work. So Katja asks, when we're making an application for settled status, do we need to submit evidence of residence, or will the system automatically pull, for example, national insurance data if we've been regularly employed for the qualifying months? And if evidence is required, would payslips and rental agreements be enough? And Rodrigo says, if I intend to apply manually for settled status next month, during the application, if my national insurance number check shows a record of more than 30 months in the last 5 years, is that then it? Is there no further proof necessary? So it's kind of asking whether the automated part of manual applications is actually going to use this new functionality.
Yeah. So again, all very valid questions. So as far as we understand, the automatic national insurance number check is not going to reflect the new approach tomorrow. So it won't be looking for 30 months residence. And if you have that, if you've got 30 months in the last like 2.5 years, but not a lot before that, then the outcome from the automatic check is not going to be grant settled status, because it's still applying the existing rule, which looks for 6 months per 12 months. So it looks for like a lack of it makes sure that there's no absences that go over 6 months. That's the way it works now. So that needs to be changed before the national insurance number will give you the outcome based on the new rules. So that's kind of a long way of saying no. Your national insurance number is not going to get you over the hurdle if you're relying on the new rules but don't meet the existing rules. So what it will do is it will give the information, though. It will give that information about your national insurance records to the caseworker, so they can see what's happening. So for what you see as the kind of applicant, you won't necessarily know what's the computer doing and what's the caseworker doing. But just to explain, a caseworker will get that data on your national insurance number, and if that does show that you've got 60 months of of residence in the last 5 years, the caseworker can then move to make the grant of settled status themselves. So I guess that's what's happening behind the curtain. But for what you'll see is you have 30 months of national insurance records in the last 5 months, therefore you get the grant of settled status without, in theory, without having to add anything else to your application.
Okay, great. And Emmanuel asks a general question about the difficulty providing evidence for some people, saying, for people with pre-settled status that never worked, for example, a housewife where the husband is taking over all the bills and rent, how can they prove 30 months of residence? Will a personal bank statement showing monthly spending in the UK suffice, or will a joint name on rent contracts or bills be valid evidence? Even if all the payments come from a bank account in the husband's name only. And I just thought maybe you could say something about whether border data will be helpful here.
Yeah, absolutely. And this is as well as the sort of simplification of the absence rule being helpful and hopefully very helpful for people applying. Also, the way in which the Home Office will assess evidence should also be slightly more straightforward, we hope, for people, and that is because of what we understand is the introduction of border data being used in the assessment of the application. So this is something the Home Office has kind of talked about for a while, and in some aspects of the settlement scheme, border data is already considered in certain parts, but hasn't been used in the application from pre-settled to settled status so far. So what we understand will be happening from tomorrow is that after the national insurance data is checked, if that doesn't give you the 30 months in 60 months outcome that allows the grant of settled status, then there is the possibility of looking at border data, which is when we say border data, what we mean is entry and exit data from the UK. So because obviously that tells you whether someone was present or whether someone was absent. So it can help to, I guess, fill in some of the gaps if the national insurance number isn't providing enough information. And that also extends to this difficulty of providing residence evidence for some people, because the point made, and it's a very, very valid point, is that not everyone has access to the kind of residence evidence that the Home Office lists on the gov.uk website. And so for some people, proving residence, even if they actually have been here, proving it can be a bit of a challenge. And it typically will affect more vulnerable groups who struggle more with that kind of evidence burden that's on you. So the use of border data could really be really helpful for people in that sense, because if it relieves the burden to provide evidence, then that's another thing that's just in everyone's favor. It's in everyone's interest to use, because it helps to get to the right outcome, but also not penalize those who don't have that kind of evidence of residence, which will typically be more vulnerable groups. We haven't seen the use of border data yet, so or in the application process. So I don't have any kind of details of how well it works to give you. There are some what you call weaknesses in the border data of how it's captured, particularly between the border between the Republic of Ireland and Northern Ireland, because there is no hard border that people cross. So it's not to say the border data is perfect, but we feel, and certainly the Home Office has said that they feel it's a very useful tool to allowing them to confirm someone's residence and relieve the burden on people to upload lots of evidence of their residence that they might not necessarily have.
Great, thank you. Okay, I've now got some questions that are to do with how the new rules interact, if at all, with the old COVID exemptions. So to illustrate this, Marina said, I moved to the UK in July 2018, and because I left the UK for 16 months because of the pandemic, I am stuck in a pre-settled status because the 5-year counting restarted when I moved back in 2022 once I found a job in the UK. I'm hoping that with the new absence policy, I'll qualify for settled status from now on, but I'd like to confirm that my understanding of the changes is correct. Would the months spent away from the UK add to the 5 years counting? I'm over the 5 years already without those months, but I thought it would be relevant to discuss anyway. I think there might be some confusion going on here, but hopefully you can clear that up.
Yeah, so just because there is that confusion in the existing rules, it is worth explaining that briefly, which is the way that COVID absences work in the existing rules is you would be entitled to, like, the first 12 months of an absence relating to COVID-19 is just it's part of your 5 years. So if you have a qualifying period where you've been mostly resident in the UK, but you had an absence of 11 months outside due to COVID, that's just accepted. You just complete your 5 years and you would be able to qualify for settled status. When you go over 12 months with a COVID absence, which many people did, what happens at the 12-month period is the clock on your 5 years is just paused. It's not reset, it's just paused. So if let's say you have 18 months outside the UK because of COVID, it's justified. You can explain why because of COVID. Then what happens was, because it gets paused at 12 months, the last 6 months of that COVID absence is added to your 5 years. So your qualifying period then becomes 5 years and a half. So that's how it would work under the existing rules. How it will work under the new rules is that if let's say, like I say, like if you're talking, well, this is a 19 month absence, they've given an example. So anything under 2.5 years, it doesn't matter whether like how that basically fits together. It doesn't matter if it's one period. I'm going to have to come back to lapsing leave because there is a bit of an issue there. Sorry, I've realized I'm straying into lapsing leave, but I'm going to come back.
We can cover that later.
But yeah, but what if someone had an absence of 18 months due to COVID, then they came back, and then they had, over the next few years, they've only had like kind of normal breaks to do with holidays that add up to, let's say, another 6 months. So in the total 5 years, they've got 2 years, but they've got this big 18-month COVID absence. Under the new rules, it just doesn't matter because you're not required to justify long absences. There's no resetting of the clock or anything like that. You just still have your 5 year period from your date of application. And if your absences in that time are 18 months plus 6 months of normal holidays, that's 2 years. That's not 30 months. You would qualify under the new rules. So for essentially for people with COVID absences, the new rules are much like they're better because you don't have to justify it. You don't have to make up time if you went over 12 months. None of that has to happen. So you just have to look at the last 5 years, factor in the COVID absence, but as long as you're in total you're under 30 months, then you're okay under the new rules, subject to me coming back to lapsing leave.
Yes, thank you. Yeah, and Karina actually sort of was asking whether you could get anything better than the 30 and 60, because she says, we wondered how the COVID year was factored into this new change. If you were absent from the UK for up to 12 months during COVID, then that absence was included as part of the 5-year continuous residence and therefore counted as time spent in the UK. Does that COVID dispensation now get included as part of the 30 out of 60 months now needed? My partner was absent for 12 months due to COVID. How does that time get factored in now that the goalposts have moved?
Yeah, so the way it's factored in is what I just explained, which is you have an allowance of 30 months absence and you can use the COVID time as part of that 30-month absence because the likelihood is it will fit within the 2.5 years of absence that you're allowed, and you don't have to justify it. But if the question is, do I get like a 30-month allowance and then whatever happened in COVID is extra to that, then that's not the way the new rule works. It doesn't give you like 30 months around like to do sort of the normal types of things that people are doing, but then it does that. Then if you had COVID, you can add it onto, because again, just to give you the Home Office perspective, is they're simplifying it. So they're making it more straightforward in the sense that you don't have to justify COVID, and if you have COVID absence that went over 12 months, then that's okay. As long, like, we'll come back to if it went over 2 years later on lapsing leave. But if it was like 18 months, 20 months under COVID, then you can still, you haven't broken your residence, you don't have to justify it, you can use it within that 30-month allowance. So this is being simplified, and it is being very helpful, but you wouldn't be able to sort of say, well, I've got a 12-month COVID absence, I also have 30 months of, or up to 30 months of other incidental absences, and so I still meet that rule within 60 months. It doesn't work like that. So if that is your situation, you'd have to look at when you can get your absences back under the 30 months in the 5 years, and that will give you your date of application. And I'm going to go back to Monique's calculator because it's so helpful to understand that information.
Thank you. Okay, so you mentioned it a few times already, lapsed leave. We're going to talk about that now. So we've had quite a few questions about long absences that mean that someone's pre-settled status may be deemed to have lapsed in the eyes of the Home Office. So, for example, Chantal tells us she was granted pre-settled status in 2019 when she was doing a master's degree. She then left in November 2019. Made a short visit in February 2022, and then has been living in the UK properly again since August 2022. Her pre-settled status has been extended, so it's showing as valid until 2029. And taking into account some little work and holiday trips abroad, she expects to reach 30 out of 60 in August 2026. Will she be okay? And Matea wrote us with almost exactly the same dates and circumstances, and for both of them the reason for the absence was being longer than 2 years was COVID related. And Issy asks a very similar question about having a 2.5-year absence 3 years ago. I'm assuming that's probably also COVID related, and her pre-settled status has even been extended by 2 years as well. So what happens to those people?
Yeah, so okay, so it's probably helpful just to explain what I've been used this expression lapsed leave a couple of times now, and I don't want to assume that anyone understands what I'm talking about, because it's a complicated concept of UK immigration law. But essentially, what the immigration law of the UK says is, where someone has been continuously absent for a certain period of time, like as in, so they have not even stepped foot in the UK for a single day within a period, at a certain point, the status they hold, which is it's called leave under the UK immigration law, leave to enter, leave to remain. That's what it's called technically, but it means immigration status. The immigration status lapses, so and that's automatically. So it kind of evaporates when the person has been continuously away from the UK for a certain length of time. That's when we talk about lapsed leave, that's what we mean. We mean someone who held status, but they were away for too long. Their status has vanished. It has expired because that's what the law says. And it doesn't mean you don't get a decision from the Home Office telling you this. It happens automatically because that's what the law says happens. So with pre-settled status, up until the 21st of May 2024, there's no significance in this date. This is just the date the law was changed. Up until that date, pre-settled status expired, lapsed, if someone was continuously absent for more than 2 years. So any absences up to 2 years were okay. If you came back, your status would be intact. Even if you came back for 1 day during those 2 years, your status would remain intact. But as soon as you went 2 years and 1 day continuously away from the UK, if that happened before the 21st of May 2024, then your pre-settled status is deemed by the Home Office to have lapsed. So you no longer hold it in the mind of the Home Office. On the 21st of May 2024, the law was changed, so the pre-settled status only lapses after 5 years of continuous absence. So the period was extended for quite an extra 3 years, essentially. So it'd be very rare that a lapsing leave issue will, for the purposes of what we're talking about here, will arise if the person is absent for 2 years after 2021, after the 21st of May 2024, if they are absent for 2 years after that date, their pre-settled status is not deemed to have lapsed. So it affects people who've got 2-year absences before that date, and a lot of those are going to fall within COVID. That's the other thing to kind of think about with how this issue is addressed, because the rules, again, when he highlighted this in the presentation, the rules say you have to have pre-settled status to be able to use the new absence rules to apply for settled status. So if your pre-settled status is considered to have lapsed by the Home Office, that creates a problem because you don't have the status required to move to settled status. It's also worth mentioning people in that situation. So they had a 2-year absence before the 21st of May 2024. The status is considered to have lapsed, but they probably will also have received an extension to their pre-settled status because the Home Office doesn't know that this is what's happened. There's no decision, as I say, it doesn't happen. You don't get told about this. So the system that the Home Office has to apply automatic pre-settled status extensions doesn't know what's going on. So it gives the person an automatic extension. So that person will feel like their pre-settled status is still there and still going. The Home Office position is that extension is not valid because you didn't have any status in the first place to apply it to. So what you're told is misleading. So it creates a real problem, a real confusion, and something which whilst the rules on absences, they are very welcome, the simplification is welcome, the simplification of the evidence using border data, it's all very welcome. But these lapsed status cases our view would be they need to be looked at, and they need to have something to make them work, because it seems unfair to penalise the people who had those longer absences in COVID-19 because like people were forced to leave in the pandemic. It wasn't a choice people had necessarily. And so to kind of, for those people to be excluded from these new, more generous rules, doesn't feel like actually what the intention of the rules is there to do. So we have a bit of a situation, and I don't have a perfect answer right now. That's the thing to say is I'm giving this sort of detailed explanation because I don't have an answer to the question. Because there is a clear problem with the lapsed leave rules applying, and the way the rules now for the new absence criteria are saying, well, you have to have pre-settled status intact to benefit. So at the moment it's difficult to give people advice because they don't necessarily have a good solution. And I think what we'd say from a kind of stakeholder engagement point, Home Office 3 Million advocacy group, is we're trying to say to the Home Office that this feels like it's not what you intend to happen, and so we'd like, we hope that there's a way of working around this, and so we'll see. Hopefully that will land on ears that listen to this, and we'll, obviously, if we can update, then we will do. But at the moment, it's really difficult to talk about it in a sort of concrete sense.
Yeah, thank you. And just to say, somebody, Francisco, emailed in with a similar question, but just to say his 2-year absence started in April 23. So from what Chris explained, he hadn't yet been away for 2 years by May 24. So his 2-year absence isn't deemed to have lapsed. Just got a question as well about previous refusals. So we had a question from Ingrid about what happens if an application is refused under the old rules. She had an 18-month gap in the last 5 years, recently applied for settled status. I can imagine she might have been worried about whether the Home Office would accept the justification for that long gap. So if that application is refused, can she then just apply again under the new rules?
Yes, that very simple. Anyone who, for whatever reason, didn't qualify, if they've already been refused, didn't qualify under the rules as they are today, has an application pending which isn't successful under the rules, as long as it's about residency, and because the Home Office doesn't take away pre-settled status, if the decision of the Home Office is you can't meet the existing residence rules, they don't take away the pre-settled status, so you still have your pre-settled status. Then you can look at the new rules. Do I have 30 months of residence within the last 60? Yes, and I have my pre-settled status, so you apply again, and you should hopefully get a positive outcome.
Great, thank you. I've now got a whole bunch of questions from people who are currently outside the UK. And again, I won't read them all out, but essentially they're from Anna, from Tom, from Laura, from Ilinka, from Stella, from Jeff, Lorenzo. They're all saying that there were reasons, a lot of them sound like incredibly good reasons, that they left the UK at some point, and often due to COVID, all their plans went awry, but they want to come back. They've had the extensions. They know that if they now came, they thought there was no chance, but they have got an extension. And now these changes of the rules means they're thinking if they come back, they could make up that time. So can you say anything about that general issue, the people who are currently abroad thinking, what do they do now? Can they chance coming back?
Yeah. So this is quite a difficult thing to discuss. And again, Monique's already talked about the idea of when the Home Office looks to cancel status or curtail it is the other way of describing it. And when they might do this, because as we understand it from the Home Office, they will look to identify at some point pre-settled status holders who have been absent for the longest periods, and then could take away the pre-settled status subject to an appeal, or and people having the right to give them evidence to say, well, your conclusions are wrong, I was actually living in the UK. So it is difficult for people who have got a lot of absences but are now thinking, well, if I commit to living in the UK for a certain period, well, it will need to be 30 months if you don't have any residence within the last 5 years, but maybe some people have some residence, but not a great deal. You are going to have to commit to a period of time of living in the UK. And then if you do meet the rules, because the 5 years is a moving period. So once you meet the 30-month rule, you can make an application, and it doesn't matter if we've already explained, it doesn't matter if that doesn't include any time before the end of 2020, the way the rule operates. So there is this kind of, yes, it could give people a new lease of life, who thought that they wouldn't be able to qualify for settled status, and sort of had said, well, I'm not going to come back to the UK because I can't meet these rules. It does give you that opportunity potentially, but it does come with a risk, because until you meet the rules, until you have the 30 months that you need to meet the rules, you can have your status taken away, because you won't qualify under the existing rules because you've broken your residency because of the long period. And when you don't have the 30 months under the new rule, you don't meet that rule. And when you don't meet any of the rules, the Home Office has the ability to take away your pre-settled status. And so it does come with a risk if you're thinking, well, maybe I'll look to move back to the UK and try to build up the time. So we have to be clear about that, and as advisors, it's important that we make that point, because we don't want people thinking, well, this is I can just do this and it's going to be fine and there won't be any issue, because we can't give you that guarantee. Again, I'm going to go back, use the absences calculator that Monique's advertising, because it will give you an estimated date, or it will give you an actual date that you could qualify, assuming that you spend all your time in the UK within that period. So you can work out, well, how long will it take me to become eligible? Because logically, the sooner you become eligible, the less risk there is of having your status removed. So you can understand that information. Some people are also going to have I've talked about that lapsed leave situation, so bear in mind that that could apply to some of these longer absences. So there could be that added complexity to the situation as well. Although, as I've said, we're hoping that that will be something that can be resolved through practical will. But at the moment, that would also be something that would sort of count against people. So it's not that I want to be excessively negative to people who now feel that they want to commit to living in the UK, but I also want to be very clear that it's not without its risks, and in the sense that it's not a risk that you will sort of, you know, that one day you will become unlawfully resident, because the Home Office has a process that they have to go through to tell you that they're thinking of taking away your status, and if they decide go through with that decision, then you have a right to appeal against it. So it's not like one day you're lawful and the next day you're not lawful, but it's just that you might not be able to qualify for settled status if you do have a really significant period of absences. You may not be able to spend enough time in the UK to build up the residence you need to qualify under this rule the way it works.
Great. Now I've got a couple of really interesting questions. We had two questions from people who have actually switched into different visa routes because they got advice that they would no longer, or that they would never be able to get to settled status. So Jonathan was told by a lawyer that because of a 23-month absence, he'd never be able to acquire settled status, so he got a spouse visa instead. And Dimitra talks about what happens to someone who, for the same reasons, switched to a skilled worker visa. And they're both essentially saying, you know, they're now in an expensive visa route, having to pay NHS fees and everything. If these rules had been brought in a little early, they could have made use of them. So partly, do you think that there's any refund possible? But more importantly, do you think they can get back to getting settled status?
Yeah, I'll deal with the refund question. I don't think so. The Home Office is not known for refunding visa applications where people have taken advice and decided that switching into a paid immigration route is the avenue for them. You know, they will say that was a willing decision, and therefore not something that we feel we should refund money for. Hopefully the more important issue would be about whether the person could potentially qualify for settled status, which of course is indefinite leave to remain with a free application, and potentially they get there a lot sooner without the need for expensive extension applications. Now, what we have, it's a very complicated situation which we're not going to get into in this discussion, but something the 3 Million has done an incredible amount of work on is there's a piece of legislation that is going through the parliamentary process right now, and if it passes, the idea behind it, or some of the idea behind part of it, is that for people who have moved away from pre-settled status into a different immigration category, potentially they've actually kept their pre-settled status rather than giving up the pre-settled status to go into the different category, which is normally what happens in UK immigration law. Rather than that, it's just they've carried on with their pre-settled status, but they've gone on a different path and got another status as well, and they're both sort of sitting there as immigration status. So that person, if that's what happens, and that's the sort of way that this legislation kind of confirms is going on, then it's helpful because that person could then use this new absence rule to say, well, now I've completed the period, the 30 months and 60 qualifying period, and I've still got pre-settled status because I never left it. I just got another one as well, another status as well, and so I'm able to apply for settled status relying on that existing grant of pre-settled status and meeting the new absence rule. So that's what we're hoping will happen. I think we need to get some confirmations that this is how it's going to work, because, like I say, it's been a change in the way that the immigration sort of statuses work. So we have to get the confirmation of that. But it looks like there might be some positive news for those kind of cases,
which would be great. Right, I'm only going to just ask you two more little other questions, and then hopefully we can have a few minutes just to take some questions that have been submitted. So firstly, Charlotte asks whether, given that the automated checks are now simpler, and given that by the end of 2025, all EU citizens should have been in the UK for 5 years, is there any insight into whether automated upgrades for status for EU citizens should occur for all? I understand she's asking this with respect to those who were only issued pre-settled status in 2021 or later, who therefore won't have approached their pre-settled status expiry date and therefore won't be picked up for automation. She's saying, why can't you just pick up all of them by the end of the year?
Yeah. There's a number of kind of answers to why that isn't going to happen. I'm afraid, like it's a nice idea, but it won't. It's not going to be what we will probably see with automation. Like now, obviously, one of the things to say is that family members who've joined after the end of 2020, which there's several 100,000 or applications as joining family members, and so because their residence did begin after the end of 2020, they haven't completed the 5-year periods. So you would only be looking at those who are resident in the UK before the end of 2020, and it would involve the Home Office being able to siphon out that group versus the family member group. And anytime you start talking about filters and things like that, you get into a more complicated automation system, and one which requires a lot of investment into. And so we probably won't see it for that reason. There's also the fact is that even if you did attempt to automate every EU citizen who was here by the end of 2020, you'd still wouldn't automate everyone because they don't have the national insurance records necessarily to be granted. So it's not going to sort of benefit everyone. So there's a few things that's going on there. So whilst it's a nice idea, right, it's just not what we're going to see. So I think we have to work with what's happening. Hopefully automation will continue to benefit people. We look at the statistics when the Home Office releases these each quarter, and we can see the number of people who've been given a grant of status automatically. Hopefully that will grow. And when the new rules are applied to the automated process, hopefully that will grow more people. But we've said it before this evening, is that what we're trying to protect people in the best possible way that we can, and give the information that helps people understand how to protect themselves. And that right now is, as of tomorrow, is to make an application if you meet the new rules. Because if your pre-settled status expiry date is not for some time, then you're just not going to be going into the automation process. If you are a family member, you're not going to be able to be automated because the system can't do the calculation on connection to your sponsor and things like that. So it's just the case of making the application. The process, the rules are simplified tomorrow. The use of border data from tomorrow really hopefully will make it more straightforward for people in terms of the evidence needed. So that's where we're going to say to people to go to help them get the status.
Okay. And then a slightly interesting question from Constantine, who says, suppose Reform UK wins the next election. Can these changes on the continuous residence, the 30 out of 60 months, simply be undone by the next government?
Yes, the government of the day is entitled to legislate how it sees fit, and obviously, and that doesn't just apply to this; it applies in any sense. So the simple answer is yes. Like the all of this could be undone. However, even a party like Reform, which I think would be fair to say is not particularly pro EU, would have to. I mean, you would think politically and realistically, they are going to have to consider the impact of what they do in the context of the UK's relationship with the EU, which is still the biggest trading partner, and so on and so forth. So things like that, trying to undo what this government has done and the previous government who introduced the settlement scheme, would carry a political risk, and whether hopefully from my point of view, that would be enough to stop the worst excesses of trying to sort of undo things that have been committed to. So that's the context. I can't say it would never happen, but I would hope realistically that this wouldn't be their priority to look at. But.
Yeah, hopefully it wouldn't be worth it to them. Okay, we now go to a few questions that have been submitted. So there's one from Giuseppe who asks, when applying to convert from pre-settled to settled status, do we also need to supply evidence for short absences like holidays?
No. What needs to be, what the Home Office needs to arrive at is a decision that you have been resident for at least 30 months in the last 5 years. So they're going to do that. First of all, they're going to look at your national insurance records to see what's there. Then, as we're told, they're going to be looking at your border records to see what that can tell them. And after that, if they're still not got a picture that shows 30 months of residence, then if you've submitted evidence to them in your application, and that's still advisable to do, by the way, or they ask you for more evidence if they need to fill in a gap, and they should tell you what gap they're looking to fill in, or gaps if there's more than one, then hopefully the combination of all those three things means that they can say, yes, this person has been resident for 30 months in the last 60 months. So at no point do you need to justify your holidays. At no point do you need to show your travel in and out the UK, as long as if you're asked for the other evidence of residency because it's obviously your main home, because you're just talking about holidays, that you could give that to the Home Office if you needed to do so.
Okay. And then someone who's stayed anonymous asks, can border data be used against you?
Yeah, I suppose. I mean, yes, if you want to sort of term it like that, the border data, in theory, it's showing a factual situation, right? It's like the fact is this person traveled to the UK on the 1st of January and they took a trip out on the 1st of February, but then came back on the 15th of February. Like, so it's the way we want it to work is to give the factual information that is correct for that person. So obviously, if that's what happens, then at the end of it, looking at the border data, if you were just looking at border data and nothing else, then you would have a picture of someone's residence in the UK over the last 30 months, sorry, 60 months, looking for 30 months of residence. And so if the border data implied that someone was absent for more than 30 months, then that's the factual conclusion that that could be arrived at that point. And then the Home Office will ask you in an application for settled status, right, we're looking, we've identified some gaps, and so can you provide residence evidence? And so so it's, even if the conclusion of the border data is, well, this person, we can't build 30 months of residence for them, that's not the end of the discussion. It's just, but that's where they'll probably factually arrive at, and then they ask you for more evidence to show it. And this is why I'm going to be cautious about border data, because I haven't seen it used, so I don't know. Like we know, I've talked about the Northern Ireland situation because it's the obvious one about a weakness in the data. There could be other weaknesses in the data. Any large data sets have weaknesses. People change their travel document. People use different travel documents to enter and exit. So it's not to say that border data could ever be conclusive. But so what we need to see is what's the practice of the Home Office when they come to use it.
Yep.
And at the moment we just don't know because we don't have it used. So we do this in 6 months, we have a better idea. And so and the engagement will continue with the Home Office, just to be clear on this. They've invited the engagement and it will carry on, because it's important to understand this. But we hope that for most people it's going to be used. For everyone who should be used positively, that's the idea of it.
Great. Then just time for one very quick one, then we've got to finish soon. But Antonella asks, if someone's been granted the extension and then their expiry date is 2029, can the Home Office cancel the pre-settled status at any point between now and 2029?
So the rules of the settlement scheme, the Appendix EU rules I referred to at the beginning, they already have the power for the Home Office to say, we think that you don't meet the residency rules, therefore you can your pre-settled status, we can take it away, subject to you being able to show you meet the rules, and then subject to an appeal if the decision is still to take away the status. So the rules exist. The Home Office right now, as far as we are aware, does not have a policy in place to take away pre-settled status for people on the grounds of no longer meeting the residence rules. There are some other situations where they can and will take away pre-settled status. For example, family relationships that have broken down, the sponsored family member might have their status challenged. But in terms of just residency, the Home Office, as far as we're aware, does not take away status just on the residency issue at the moment. As Monique said again at the beginning of the presentation, the Home Office have said to us that they're looking for the people who have been absent for the longest, because it's logical, because those are the people who haven't committed to living in the UK, which is the whole purpose of the EU settlement scheme. So it's logical that they'll try to identify those people who've been away the longest and say, well, if you haven't been living here, you don't meet the residency rules, we're going to take away your status. So but that policy right now isn't operational. So we will hopefully get more information from the Home Office, and again, they've invited the stakeholder engagement, which is positive, so we can understand more about this and see how it will be brought in, and hopefully have some information before it's brought in so we can explain what we understand about it. So we will be able to talk about it, we hope, in the future. But at the moment, it doesn't apply. But will it apply by 2029? Yes. Unless something drastically changes with the approach from the Home Office. Yes, we will see the policy to take away status that notionally they're talking about at some point late in this year. So that's as much as we understand. But we don't have any real details about it yet. We want to talk about it with the Home Office, and we will talk about it with everyone once we know.
But even if, as I understand it, currently the intention seems to be that even when they start doing this, they're going to be looking at people whose status is just about to expire, which means that they wouldn't be picking up someone whose status is only expiring 29. But of course, we've got no guarantee that that might not change. So that's the problem. We've got no
fully take your
guarantees.
point. Yeah, at the moment, yeah, exactly that. At the moment, the state the point in which the Home Office chooses to look at someone's status is at the expiry date. But at the moment, the only choice that they have is, do we automatically move this person to pre-settled status, to settled status, or do we extend their pre-settled status by 5 years? That's the decision process that's taken at the moment based on the expiry date of the pre-settled status. In the future, looking at the expiry date, it seems that the additional decision that could be factored in, which it will be, should they get settled status automatically, should they get 5 years of pre-settled status, or should they have they been absent such a long time that we think that they should have their status taken away. So it's an additional assessment, but it's taken still on the date of the expiry. But we don't, yeah, but you're right. But that's how it works today, and how it may work when they introduce it. But whether it will always be that way, we don't know.
Exactly. Okay, well, thank you. That was incredibly helpful. I'll pass back to Andrea now, because I'm very conscious we've overrun by a bit.
Thank you both so much for sharing a wealth of really crucial information. Yeah, so following up from the webinar, we'll share the recording in due course, as well as the absence calculator. And for those questions that we didn't manage to get to today, we'll also compile a Q&A document, which we'll share in the coming weeks. So please do share these resources with your friends, with your family. We can all see how complicated these changes can be. So it's really important that as many people as possible are made aware and understand them. I want to say a big thank you to Chris and to Seraphus for their support. So Seraphus is a law firm with experts like Chris on the EU settlement scheme. And if you need any advice and support, you can find their contact details on our website, and you can find the link in the chat as well as other advice organizations' contact details. At the 3 million, we're really delighted that the government has taken this pragmatic approach and announced these changes. And from now on, we'll also continue to monitor their implementation. So we run a peer support group for people who have broken their continuity of residence under the old rules. So if you want to join with others, have that space to share any worries, any concerns, you can still join that group. You can find details in the chat. We also continue to campaign to fix digital status, because all of us, no matter what our status is, don't actually have physical proof of our rights. So if you experience any issues, any problems accessing your UKVI account, generating a share code, or while traveling back to the UK, please do report it to us. And for those of you who are keen to do more, you can also express your interest in joining our EU Citizens Campaigns Network. We have a day of action coming up on the 9th of August in Feltham and Heston. We'll be going to the Immigration Minister Sima Malhotra's constituency and connecting there with other EU citizens on the ground, really coming together to send a clear message to the minister that digital status is failing. We've been raising these issues for a long time. So, and all of this, the positive changes that we've been talking about today, they wouldn't have been possible without the support of people just like you. So if you'd like to help and support the 3 million to keep being able to provide this kind of event, demystifying immigration rules, to keep organizing from the grassroots so you get your voices heard, and to keep advocating for your rights at the highest level, then please consider making a donation. Even if just a few pounds a month, it might not seem like much, but actually these regular donations give us a lot of peace of mind and help us to focus on what really matters. So delivering help where it's needed the most. Finally, just thank you to all of you who joined us tonight for being part of our community. And thank you again, Chris and Monique. And I hope you have a really good evening. Goodbye.
Thanks, Andrea, and bye, everybody.